Hi, my name is Attorney Joseph Radzwion IV, your trusted attorney with Radzwion Law PLLC. Today on Story Time, boy, I've got a story for you. So I handle arraignments all the time in district court for criminal matters, and I have a story about an argument that I had with a judge just last week or a week or so ago. So if you're not familiar just briefly with the criminal justice system, before the law changed, I want to say 2, maybe 3 years ago now, maybe even longer than that, the process in which someone would get arrested, be brought to jail, they would have their formal charges read to them is called an arraignment. And at that arraignment, the defendant was not represented by a lawyer. The judge essentially would read the charges to them. They'd ask them how they would plead, and the individual would either say guilty or not guilty, or depending on the charge, the judge may say this is a pretty severe charge. The court's going to enter a not guilty plea and have the case set further down the road so you have a chance to discuss it with your lawyer. Now, since the law has changed, the arraignment procedure is roughly the same. However, the defendant now has the right to counsel, meaning that a lawyer first speaks with an individual who is being charged and essentially goes over the person's or the defendant's advice of rights. And essentially, that means the lawyer is going to explain things like, you have the right to remain silent. You never have to say anything to a police officer, a judge, or a prosecutor that's going to get you in more trouble with your case, that's going to incriminate yourself. Things like you have the right under the Sixth Amendment to have a lawyer represent you in all of your criminal proceedings. If you cannot afford to hire a lawyer, the court has to appoint a lawyer to your case free of charge. Being charged criminally, you have the right to a jury trial in which the prosecution bears the burden of proof to prove your case beyond a reasonable doubt, or their case, I should say, against you beyond a reasonable doubt in order to successfully, find you guilty. So things like that are discussed with the defendant before the lawyer and the defendant step in front of the judge. The judge then reads formally what the defendant is being charged with, asks them if they understand their rights, asks them if they understand what they're being charged with, and then requests how would you like to plea? How would the defendant like to plea? The judge will essentially go into, you can plead not guilty, guilty, whatever. The defendant most of the time will say not guilty. A court hearing will be set further down the road. They'll get a chance to discuss their case with their attorney a little bit more in detail. So that's essentially the gist of the arraignment process in the criminal justice system. Now, the argument that I had with the judge several weeks ago was that the individual being brought up on felony charges for carrying a concealed weapon, which is a felony here in Michigan, you can spend up to 5 years in jail and $2,500 in fines, and you'll lose your right to ever possess, own, or carry a firearm again, unless expungements and a bunch of stuff we don't have time to talk about today. Now, the point of this story, again, is that at that arraignment procedure, bond is addressed. And bond is the simple conversation of the judge looks at several factors like, is the defendant a risk or a threat to the community? Is the defendant a risk to maybe a victim? Or are they gainfully employed? Do they live locally to the courthouse? Are they a flight risk? All of these things take into consideration what the judge is willing to do with a bond amount. If they set a bond at $10,000, 10%, that means you as the defendant will have to post a $1,000 bond in order to be released from custody until you come back for your next court date. If you violate that bond, you forfeit the money, etc., etc. So the point is that my client, once we went through his rights and what he was being charged with, we said not guilty. We want another court date to discuss and go over his charges. The judge then went on to address bond. The judge looked at what the charges were allegedly, or the charges that are allegedly being brought against my client, and she's saying that, well, based on allegedly, again, the client carrying a concealed weapon without a permit, without a license, that he inherently must be violent. And that was the conclusion that the judge drew. Now, anyone with a sense of understanding of the carrying a firearm or owning a firearm, that doesn't mean that you are inherently violent. Now, again, I expressed to the judge this, and she then went on and looked at the other charge, which was the individual allegedly had in his possession several other items that could be used in self-defense, but the judge thought that those items are not legal here in Michigan. Now, I know that they are, and the judge continually pointed to these factors as being, and then painting the client as, well, he has these things, therefore he must be violent. I then expressed to the judge that, first off, owning a firearm does not make you inherently violent. No more than owning a car and alcohol makes you a drunk driver by default. That makes no sense. Now, the other thing that I brought up for the judge to consider was that the code, or the section of the law that the prosecutor is charging my client with as a felony of possessing a firearm in a motor vehicle. We'll use that as an example. I said to the judge, this section of the law is so nuanceable that I could be following 4 out of the 5 requirements, but if I don't have my firearm locked in the proper box, if it's not in the proper transportation or the proper firearms container, I can be in violation of this law. And does that mean that I'm a violent person? The judge still wasn't buying it. The judge still would not reduce bond on this file. I'm looking forward to addressing bond again at the next hearing. That's it for this one, guys. Remember, none of our videos should ever be taken as legal advice. And if you like story time videos like this, please leave us a comment below. It really helps me determine what topics you guys like covered. And we'll see you on our next episode. Until then, stay out of jail, stay safe.